Hello, everyone. I am Netta Sagafi. I am Vice Chair of BHBA's litigation section. I am delighted to introduce our speakers today, the Honorable Anna Maria Luna, Nadine Khedry, and Wyatt Vespermann. The Honorable Anna Maria Luna, who's retired, currently is a mediator and arbitrator at Signature Resolution with more than 4 decades of legal and judicial experience. She served nearly 33 years on the bench, including as a Los Angeles County Superior Court judge, handling family law, probate, and trust matters, among them being conservatorships, guardianships, and will and trust disputes. In 2022, she was assigned to the long cause probate calendar. She has lectured at the Special Needs Planning Symposium, the Stetson Law National Conference on Special Needs Planning and Special Needs Trust, and the USC Annual Trust and Estate Conference. She is a past president of the Latino Judges of California and a former member of the California Judicial Council. Wyatt Vespermann is an attorney and a colleague of mine at Panish, Ravipudi LLP, focusing on pharmaceutical mass torts and foster care abuse litigation. He has handled significant cases on behalf of minor clients, including a $26 million verdict for a foster child in a sexual abuse case and a $32 million settlement for an infant harmed by Child Protective Services failures. He is a member of the Consumer Attorneys Association of Los Angeles and is admitted to practice in California and Nevada. Nadine Ninva Khedry is also a stellar colleague of mine and an attorney at Panish, Ravipudi LLP, focusing on catastrophic personal injury, sexual abuse, wrongful death, and product liability cases throughout California and Nevada. Her work includes a $13 million jury verdict on behalf of a minor victim of sexual assault. And she is an active member of the Consumer Attorneys Association of Los Angeles and sits on the Consumer Attorneys of California's New Law Division Board. So we have a great panel here for you today, and let's go ahead and get started. Thanks all for being here.
Thank you, Netta, for introducing us. We appreciate it. I am excited to speak on this topic because I know it is a little dense, but nonetheless, it is very important because there are a lot of hurdles that can delay payment for your client if not done correctly. So we're going to be going over some of the tips and tricks that we've accumulated over the years to try to get our minors comps passed through the bench. And Judge Luna is going to be offering her perspective from the bench as to what judges are looking for, what is helpful in trying to get your minors comp approved. I don't know if you all have been there, but sometimes it takes a few rounds to get these things through. So we want to try to avoid that as much as possible. So,
and I'm not usually shy around lawyers. We're just having some technical difficulties on my computer, but we don't like the continuances either. So I'm happy to be part of this panel.
Great. Thank you, Judge Luna. Sorry about the technical difficulties, but she's here and is willing to contribute. So, okay. So we're going to go over just a quick overview of kind of how the program is going to go. I'm going to talk about, generally speaking, how to get the minors comp filed, the technicalities of it, tips that I have. Judge Luna is going to go over some the expedited process, which can be helpful if you have a certain threshold of a settlement, and why it's going to be going through some of the options that are available to your client when they need to structure the money or put it in an account or any of the interest-bearing, options that are available to them. Okay, so how do you get your minors compromise approved? So that's just the general gist of this segment. And these are the general forms that you're going to need to get it filed. So first things first, this is kind of the bread and butter, is the MC 350. It's the main form. It's a judicial council form. You can pull it offline. You can pull it off Westlaw and the form builders, which is always helpful. But if you have your cases set up in there, that has to be filed in every single minors comp case, right? Any case with a minor. You also need the order approving the compromise, which is MC 351. Think of that as like a proposed order, similar to how you would have one for a motion. And then if you end up choosing to put some funds in a blocked account, and we'll go over why you would want to put some funds in a blocked account versus not, that is the order that the judge signed. It's like an additional proposed order, but that order goes to the bank. So the bank knows that the judge has ordered funds to be deposited into a specific type of account. And for those of you maybe who don't know what a blocked account is, a blocked account is a bank account that, for the most part, major financial institutions, B of A, Chase, Wells Fargo, some credit unions also offer them, but it's a bank account that you deposit the funds in. It can't be touched until the minor turns 18. It can only be opened with a court order, so you need the order from the judge, taken to the bank. Your client takes that order, and the bank opens and deposits the funds into that account. The only way funds can be taken out of that account is through a judge ordering it. So essentially, from the time the settlement is approved up until the time the minor is 18, anytime the client would want money out of there, they have to go into court and file it's like an ex parte essentially. And then the last thing that you need if your client does get a blocked account is an MC 356. That basically is for the bank to sign off on to say that the account's been opened and the funds have been deposited and they're not going to be touched until they're 18. I've been lucky for the most part, and my clients, if I give them all the documents they need, they go to the bank and don't have any issues. I know sometimes lawyers do go with their client to do this process. It's probably not a bad idea, but I've lucked out. If you have to go, if they have issues, maybe go with them the second time.
I think it would be important to note that I think the court sometimes operates under the idea that banks still function they did before COVID, and will set a like a 6 to 8 week time limit to get that order confirming deposit back to the court. And the reality is, as you all know, is that banks, it's very difficult to get in. You have to make appointments. The appointment times are not necessarily convenient to the person who's establishing the account, generally a parent. And then the bank, your client turns over that MC 356 form and never sees it again. So I just have a couple tips and tricks, I think, that might help. Sometimes it's better to not deal with one of the mainstream banks, such as Chase or Wells Fargo or Bank of America, and to look for a bank that really is used to handling these types of accounts and can actually set it up without even having somebody go into a branch. So you might look at places, and I'm not endorsing these, I'm just saying they're easier to deal with. My experience is Cal Private Bank or Manufacturers Bank. So somebody like that, or a bank that your office might have a relationship with, that would make it easier to get the account established in the form back into your hands or your client's hands for submission to the court. My second tip, and I use this usually on the second or third appearance when somebody was coming in and saying, look, I went to the bank, I set up the account, but I can't get the form that I gave them back, is to advise your clients when they go in to set up the account, get the business card of the branch manager. Because if they come back to court, or you come back to court and say, look, we can't get the form, it's lost in the black hole of legal for Wells Fargo or Chase, then we can set an OSC for the branch manager to have them explain why we can't get the form. And that usually gets everybody's attention. So that's my suggestions to avoid multiple appearances trying to get this form submitted to the court.
No, those are really helpful pieces of advice that would help streamline things. So the MC 350, like I said, is kind of the bread and butter. Basically, this form goes over the details of the settlement. Who's the guardian? At the time you file the lawsuit, you're likely already going to have a guardian ad litem appointed to bring the lawsuit. So it needs to identify that person. It needs to identify the facts of the case, the jurisdiction, basically the case status, where it's pending, or if it's a pre-litigation claim. Judge will want to know basically what are the facts of the case, just a general overview, the injuries that your client suffered, the treatment that your client got, the prognosis that your client is going to have as a result of these injuries, right? If there's going to be a decent amount of future care, that's relevant in determining whether the settlement is fair or not fair. Gross settlement amount, your fees, costs, and expenses, make sure that those are itemized. And then, the liens have to be outlined as well. And then after subtracting all that, the net recovery the client is going to have. I saw a question in the question box earlier that was asking about costs of an expert hired to reduce a large figure lien recoverable. Generally speaking, not talking about minor cases. Yes, I don't think I have submitted that cost for a minor, but I will just say this as a precautionary is make sure your client consents to that cost prior to doing it. It's kind of an unusual cost, I would say. So usually if I'm going to do that, I've probably only used them a handful of times, but they are helpful on especially like an ERISA lien or a really big Medi-Cal lien. I've gotten some decent reductions. I just put everything in writing for the client, explain to them who the service is, how much they're going to charge, and if they're okay with that, we can proceed. I just get some sort of something in writing, just or explain to them over the phone, and then send a follow-up email saying, as we discussed, you're okay with using this service.
I will say the one cost and expense that seemed to aggravate at least my probate colleagues and myself was something called administrative fees, which was like just like office overhead, it seemed to us. And we never liked seeing that. Oftentimes, I think it would get disallowed. If you've got extraordinary expenses for photocopying or mailings, those are certainly legitimate to submit, but give an explanation as to it. But if it's like $500 just for, keeping the lights on type administrative expenses, you're not going to have very much success with recovery of those types of expenses.
Absolutely, absolutely. And somebody brought this up too, is yeah, the blocked account is self-executing. So when the minor turns 18, they can just go into the bank and get their money. But up until the time they're 18, they need a court order to get out any money.
Well, it should be self-executing. I will say that banks are cautious because Chase Bank got hit for a money judgment because they released money from a blocked account in violation of the order. So we've actually had, at least on the probate side, have seen individuals turn 18, come back in and say, we need an order saying it's okay to turn it over to us, even though we're 18. So just throwing it out there. I think banks have gotten a little cautious since one of them got hit for a judgment.
Mm. Andrea, you posted a question about what do you have to file to represent a minor. I don't think you can do it absent a GAL or ask grandma to get a guardianship. Yeah, I mean, those are really your only options. I don't know if Wyatt or Judge Luna, you have any insight to that. You got to have somebody
No,
appointed.
it's in the civil code. You have to. It's a requirement. And sometimes you find challenges because I do these foster care cases. You have to find sometimes even a professional, like a pro bono attorney, to serve as gall. There is no case of a minor without a guardian ad litem. You would lack standing without one.
Exactly. Yeah. Like I said, like Wyatt said, there are professional ones that you can hire, or the court can appoint a guardian ad litem, is my understanding. I've never done it, but I know that's a possibility.
That's correct.
Okay. So the disposition of funds, these are your options: the blocked account, the structured settlement or annuity, or the special needs trust. Talked about the blocked account a little bit. The structured settlement is essentially a vehicle to invest money that will accrue interest tax-free and allows payments throughout allows payments for when the minor turns 18 spread out throughout their life. Special needs trust allows the money to be placed into a trust so that the minor can use them for different types of things that may be related to the case. And Wyatt will talk more about that, what can and can't be taken out of the special needs trust. But the big thing with the special needs trust is it protects governmental benefits. Okay, so, we were talking about this a little bit earlier, the injury. This is important because the judge is going to want insight as to the type of injury, the treatment that they received, and whether or not that injury is going to be permanent. Main things judges are focused on, right? Is it a fair recovery to the minor? Are the fees and costs justified? And does the vehicle that the client and attorney have chosen to put the money in protect the minor's funds? This is really the overarching thing. That's what the point of minor's compromise is to ensure that nobody is taking advantage of the minor, whether that's the attorney, whether that's the parent or the guardian. The judge is really the protector of the minor in this case. Okay, I often hear this, and it's a misconception that you automatically get 25% for a minor case. It is a kind of a general rule, but it's not always, set in stone. Don't sign your retainer at 25%. You don't know what type of complexities are going to come up in the case. And if at a later time you submit a fee for higher than 25% and you put in the justification, the judge can approve that, right? But you're just going to need justification. Outside of that, courts can reduce the fee on their own if they'd like.
And they do.
Yeah, and they do. So what really do you have to do to justify your fee if you're trying to get higher than 25%, right? You're going to outline the complexities of the case, the risk that you assumed if it's a contingency case, the work that you performed. You really have to sit and detail it out for the judge in your declaration as to what you did up until the time the case got to you, up until the time the case settled, the results obtained. So, compare it to other results in the area. If it's an exceptional result, note that in the declaration and say, potentially even I did a verdict search and this settlement was well above verdicts that I have found, and the time invested, obviously. Got to talk about why the settlement's reasonable for the circumstances. Maybe it was a very good settlement considering the circumstances. Maybe liability was heavily disputed. Were there policy limits issues? Did you get personal contribution? Was there comparative fault issues? Was there collection issues? All those things should be noted if they were part of the case. Okay, the guardian, parent info, you should have their information, which is required on the form. Make sure that that guardian doesn't have any conflicts of interest when you're appointing them at the beginning of the case. And then you can have a declaration even from the guardian saying they understand, the settlement, they're acting in the minor's best interest. You should have them present at the hearing, obviously, for the judge to inquire with them as to what they think about the settlement. Obviously, it's really important prior to the hearing that you're on the same page as your client. You don't want your client going rogue on a minor's comp and saying that they don't agree.
If I could just say, go ahead, Judge Luna, go ahead.
I was going to say on the conflict of interest, it's not infrequent that the person who's the petitioner is a parent. It may be a parent that's also going to share in the recovery. And maybe it looks like they're getting more of the funds available for settlement than the minor. So I think when it comes to addressing who your guardian ad litem is, you should look at the case from that perspective. Obviously, we have single parent households and maybe there isn't another parent or somebody able to step up as a guardian ad litem, which means you should be very careful in your declaration to explain you have to be very careful in your declaration to explain why it is that the parent's receiving X amount and the minor is receiving, relatively less or less than the parent. So just be very careful and attentive to that in your declaration.
That's a great segue to a red flag that a judge will raise if you have that in your declaration as to why the parent is doing that. Other red flags, if there's limited work, there's a high amount of costs and fees compared to the settlement, lack of the documentation, or there's a high fee compared to minimal recovery. Best practice is to have a declaration. I know somebody asked if the judge wants to see an itemized billable time. Not necessarily, but you should treat it pretty detailed. I go through pretty much everything I've done in the case. I prepared and filed the complaint. I served it. I responded to discovery. I spent X amount of time going through the discovery with the client. I prepared my client for deposition. I sat for the deposition with the client and just go through each docket item, basically.
If I could piggyback real quick,
Yeah.
I will, if I get, hey, I need more information to justify your fee, I have gone through and tried to itemize. It's kind of it doesn't need to be your foot forward, but if they're requesting more information, then it really does doesn't have to be exact, it can be estimates, but every little thing, I put a time on it, I put a total on it, and I try to show my math, because sometimes that's what they need if you're going to ask for a fee above that 25% threshold.
Okay, this is an example of a detailed declaration. I put in prior results. Also put in prior cases and court orders where fees and higher than 25% have been approved, because I've gotten pushback from judges saying, well, I've never, granted over 25%, or I'm not aware of courts that are doing that. Well, Your Honor, here are the court orders from previous cases that I've worked on where judges have granted above 25%. Okay, this is the checklist, right? So you need the petition, you need the order, and then the 355 and 356 are necessary if you're going to do a blocked account. I'm going to quickly go over this so I don't run into too much time here, but sometimes your settlement is confidential, or your case involves confidential information that you wouldn't want in the public record, right? So if you do want to have some of the petition redacted or filed under seal, you got to file a motion for seal. Obviously, it's presumed most court records are public. So in order to do that, you got to file a motion to seal that talks about why there's an overriding interest for this information to be private. Generally speaking, in the cases I've done it on, the settlement is confidential. And so I submit a motion for seal to redact the financial information included in the petition. So I'm just redacting the numbers basically within the whole petition. And it is really actually for the protection of the minor too. Imagine there's a public record talking about this minor getting millions of dollars. It's going to make them a target from family members or others around them. So other reasons why you would want a motion for seal is if the case involves maybe a sexual abuse allegation, but generally they're filing under a Jane Doe anyways, or if you're submitting medical records attached with the minor's compromise, maybe you would want those filed under seal, or if there's any type of psych treatment, you would want that filed under seal. They won't seal the entire file, so it has to be narrowly tailored. So maybe you're only sealing specific exhibits, or you're redacting certain information. So how does this really work practically speaking? You got to file the notice of motion and the motion to seal, submit a declaration with that saying why it's necessary and the harm that would be caused if you wasn't under seal. You got to submit a proposed order. And then what you'll do is you'll lodge the unredacted petition conditionally under seal, and then file a redacted version publicly. So somebody asked, how do you redact the numbers? I just use Adobe, and there's a redact feature, and you just go through and block out all the dollar signs. Practical filing tips. Some courts require that you file in probate. Others allow you to file in civil. Check the local rules. Also check the local rules regarding the motion for seal. Sometimes courts have different orders they want you to do things in. Sometimes you got to open up a separate probate case to get the minor's comp approved. I think that's true in Riverside.
I would just say in LA, if the minor's comp is coming out of a case that's been filed in the civil division, that courtroom will handle the minor's comp.
Okay, I'm going to shift gears here, and Judge Luna is going to talk about expediters, minor's compromise petitions. I think somebody asked what the minimum requirement is, so we'll go ahead and go through that.
Because I'm having a coughing fit here too, on top of the tech issues. All right, so the expedited petitions are basically, as explained by Nadine, they just have a different number, MC 356 350 EX. It's all the same in terms of the petition. The only thing that's different, you can forward the slides. Next slide, please. Is that you'll see that the section 3 is a little different. The qualifications are that the claim can't arise from a wrongful death of a person, There's no establishment of a trust, so no special needs trust, no pooled trust, no anything. The liens are all resolved. The total amount of the settlement for all parties is $50,000 or less, or if it's greater than 50,000, that this represents basically policy limits, and that there's been investigation to show that there is no other way to satisfy a judgment in excess of the policy limits from the defendants. So those are the qualifications for an expedited petition. Next slide, please. And the petitioner's attorney can't have any involvement with the insurance company in terms of like being the person selected by the insurance company to represent the minor. Here, they're just looking to make sure there's no collusion going on between the attorney representing the minor and the insurance company. Next slide, please. All right, so I think the biggest benefit of the expedited petition, if you fit in those parameters, is the time in which it has to be decided by the court. Some judges would say it's kind of the bane of their existence as you see one more thing coming in your digital work queue, but it has to be determined within 35 days after it's filed unless the court has set a hearing. The rule provides that, the court rule that is, provides that it should be determined without a hearing unless the petitioner, and I can't imagine why you would file for expedited and then have your petitioner request a hearing, or someone objects to the minor's comp being approved, or the court on its own schedules a hearing. And that may come about because there's some questions with regards to the documents you've submitted or have not submitted in support of your application. Next slide. So again, the court has the discretion to set a hearing, and such hearings require that the court give its ruling within a certain period of time. So this is not anything that judges can let sit around. They have to act on it one way or another, either review it and grant it. Sometimes if it's a small amount that's going to be adjusted, the court can just go ahead and make the adjustments in the order. But if there's something significant, then the court will set it for a hearing and get the parties before the court. And then everything that Nadine said about having your client and the petitioner available kicks in. Next slide. And I threw in some cases there that talk about fees and where it was improper to rely on one factor in terms of setting the fees to be paid to the attorney on a contingency. I put another case in the link so that you've, in the chat, so you've got that one as well, Gonzalez v. Chen. And then I know we're going to get to special needs trust, but for any practitioners out there that aren't familiar with special needs trust, if you just read through McGee, fairly recent case, it gives you a good overview as to what special needs trusts are about and what payments can be made on behalf of the beneficiary of the special needs trust by the court, can be approved by the court. So it's a good read if you're not familiar with that area of the law.
All right. So I'm going to be
sorry, I didn't mean to interrupt, but I just wanted to answer a couple questions that were in the chat before we jump into this. I think there was a question about what happens when a minor has hired two lawyers, one substituting in after the other. Is it two petitions or two declarations? My understanding, and anyone correct me if I'm wrong, I think it's just one petition. And then it's the overall attorney's fees that the judge is concerned about. How you divvy those up is not an issue. If you and the attorney, obviously, I mean, this is true anytime you get subbed out, right? Or somebody gets subbed out. If you and the attorney can figure out it amicably to how to divide the fees, then that's great. And that way you won't have to deal with it probably with the judge. Nonetheless, I think either way, you probably wouldn't have to deal with the judge because it would just be the total amount of fees. And then those fees are held in trust until you figure out the fee dispute. Judge Luna, Wyatt, any difference?
I think it could be also, obviously an attorney lien can be asserted. So if it's being handled as quantum merit, there may have to be some itemization by the original attorney, and then that lien would be presented as part of the minor's compromise petition. But I think that in terms of evaluating the attorney's fees, that quantum merit would be all wrapped up into the same analysis.
Right.
Yeah, I agree.
Okay. And then I think there was mention, we have another judge on the webinar today. Judge Rosenblum mentioned that parents can be the representative for their minor children, no ex parte for appointment as guardian ad litem. We DWOP them. I don't know if I haven't done that before. So
That's deny without prejudice. Yeah.
okay. I got the judge's lingo down. Perfect. Okay, Wyatt, I think we're
All
good to
right.
go.
Let's unpack our funding pathways for minors compromised and disabled adults, because getting the settlement, getting the money, that's half the battle, but making sure the money is going in the proper venue is the next half. Because if you get that wrong vehicle, you're causing benefits problems potentially. There could be cash flow problems. There could be administrative headaches for the family. So you want to get this right. So go ahead and the next slide. All right, so similar as before, everything revolves around the MC 350 form. Item 18 is where the disposition menu is. And it's where you tell the court exactly what you're thinking in terms of the post-settlement plan. Next slide, please. And we're going to kind of flip through this, but there are a lot of options. So go ahead and go to the next slide. And then the next slide. So there's about 20 sections and subsections, depending on the circumstances of the child or the disabled adult. Subsection A is going to be where you kind of have someone who already has a guardianship or a conservator, so more that disabled adult category. Whereas subsection B is typically where I encounter, and I'm sure most personal injury practitioners representing minors will be designating their funding structure. So usually there isn't a guardianship or a conservatorship of the estate, but you're going to be checking one of these boxes for the court to signal what it is that you're thinking. There is some overlap between A and B, but like I said, most of the options are going to be in this B category. Let's go to the next slide. And you don't just do it in the petition, you're also going to do it in the order, and that's typically in section 8B2. Which is, as you can see, a pretty small box. So if it's a complicated funding structure, then you're going to have to do this on at least one attachment, sometimes multiple attachments. And so you put it in the petition through the section 18, you put it in the order 8B2. So it's in both places so that you tell the court what your plan is, the court agrees with the plan, that's where they're going to sign and put it and write it into the child's history. Let's go to the next slide. All right. So there are a lot of different options, but there are some that are more common than others. And so, I've listed 5 here. This is not exhaustive. There are multiple options that may be appropriate for your client's situation, but the ones that I'm going to be hitting are the blocked account, which we've already kind of had some foreshadowing on, the special needs trust, which we also kind of talked about, a pooled special needs trust, which is a little unique, a statutory minors trust, which is also unique. There's particular circumstances where it makes more sense. And then the last one is going to be structured annuity. Now, the key thing to remember is that these options, they're not always either or, because under Probate Code 3611, the court can order any one or more of the available dispositions. So in practice, I will mix and match. So we will maybe have a blocked account, and we're going to allude to these scenarios: blocked account for immediate cash, a structure for the bulk of the funds. Or we might do some immediate cash into a trust while we do another long-term management, like a structured annuity that flows into a trust. So I'll go through some of these scenarios here in a little bit, but one thing to keep in mind is you're not restricted to just one bucket. You can use multiple options. So let's go to the next slide. All right, so before we get into the funding vehicles, let's talk briefly about some of the jurisdiction. Los Angeles, like we've alluded to, has some local rules that you'll want to apprise yourself of, because they can make or break whether you're going to get this done efficiently. So let's go to the next slide. All right, so here we're looking at the current local rules, which obviously you got to always check. They change. Here we see this is 2026 at the bottom of the screenshot here, but you got to keep up to date with these things because they do get updated periodically. So here Most cases are going to be into section 4115A2. There's usually a civil action, but not always. You can have a compromise pre-lit, which will dictate that you're going to go to the probate court for your minor's compromise. Whereas if there's a pending civil action, this is typical in my experience, then you're going to be doing it with the judge who oversaw the case. And let's go to the next slide. But there is some interaction with the probate court when you are going to be involving a trust. And so we see that here in the local rules under subsection B. So the probate division must review the terms of the trust. And so there's some steps that the party must take, and that's party meaning the attorney is going to be driving this, is that they need to make sure that within 2 court days of filing a petition to approve, that you lodge with the probate division a physical copy of the petition to approve the compromise and the proposed trust instrument and proposed order approving. So you got to have all your ducks in a row at the time of that filing so that you can then send it to the probate department so that the 2 courts can work together to getting this thing approved. Let's go to the next slide. But that's not the case in every jurisdiction. I think Nadine mentioned this earlier, is that, for example, Riverside, the civil division has no role in the determination of the petition for minor's compromise or disabled adult. You're taking your personal injury settlement or minor's compromise, and you are filing a brand new action with the probate office. That means that you're dealing with a judge who may not be as familiar with a minor's compromise or personal injury settlement. So more the reason why you need to be diligent in completing some of the other aspects of a minor's compromise, like your attorney's fees, etc. Let's go to the next slide. We'll quickly hit the law. It's a little dense, but we're looking at Probate Code 3604, and I've just kind of pulled out some of the subsections. This is what establishes the eligibility for a special needs trust. And so you see, the language of the law kind of speaks for itself, a little dense, but you have to have a disability that substantially impairs the ability for the individual to provide for their own care. The disability has to be likely to have special needs that will not be met without the trust. And the money to be paid to the trust does not exceed the amount that appears reasonably necessary to meet the special needs of the minor person with disability. So those are the eligibility requirements that you're going to want to have in your mind when you're determining if a special needs trust is appropriate. I pulled out subsection D as well, because it's kind of an interesting fact that you need to be aware of, something to disclose with the family when you're talking about this, is that every dollar that this public benefits will pay out on behalf of the beneficiary of this trust is going to be subject to a lien, meaning that when this trust terminates, for example, upon death of the beneficiary, then the state is going to need to get paid back first before any of the heirs are going to touch any of this money. So they have a first lien on the trust. So just something to be mindful of when you discuss this with a family or a guardian ad litem.
Yeah, Wyatt, I've actually dealt with that before, and it's like a hard conversation to have with the heirs because I had a personal injury case, and then the client passed away, and then the lien was higher than the amount that the trust was, and it was going to wipe away pretty much everything. So,
and the other thing I think to keep in mind is, as we've seen, is families will leave the jurisdiction of California for other states because the cost of living is cheaper. And my experience with some other states is they know that the beneficiary of the special needs trust is dead before the beneficiary does. And they're looking to claw back right away on the money. So I think it's a hard conversation to have, but as our families are mobile and making decisions overall that may take them out of state, it's a very, very important discussion to have.
Let's go to the next slide. So this is Probate Code 3611G. There is kind of another pathway, and we're going to go through some scenarios where this may be appropriate. This is what been referred to me as a statutory minors trust. And so it's essentially a different trust vehicle, doesn't have the eligibility requirements of a special needs trust, has, we'll get to it in a little bit, some more flexibility in terms of how the money can be spent. So this is the other trust vehicle that may be available to minors. It will become revocable once the minor turns 18, meaning that now they're an adult. They will be able to revoke the trust, turn it into whatever liquid cash or assets that may be available, depending on how the trust is structured. So this is the other trust vehicle that's available for a minor's compromise. So let's keep going. Okay, all right. So I talked about some scenarios, mix and match. Let's go with, I would call this the typical scenario. I think this also, Nadine, I think you kind of alluded to this earlier. So let's go to the next slide. All right, so it's kind of two main buckets of funding, the blocked account and the structured annuity. And so the blocked account, it's kind of that like break in case of emergencies type asset. And not all funds will be appropriate for a mix and match like this. If it's a small, like let's say it's a small dog bite type case, and there's say less than that $50,000 threshold, you may just go all blocked account and it just sits there until the minor turns 18. Great and wonderful. Then they have some cash available. But if it's getting into that 6 figures, 7 figures, then this is kind of the right 1-2 punch. Not a ton of money will go into the blocked account, but some that, hey, if there's an emergent need for this child, we have this available. We can make our application to the court. We can get some funds to the child pretty quickly. But the structured annuity is going to be kind of the main vehicle for growth, so that this money doesn't just sit there, not earn any interest, not earn any value, so that when they actually get to the age of 18, they can have some return on these funds that have been sitting there for however long. It can also give you a little bit of control over the money, because you'll see with these annuity structures, and we'll have some examples here in a little bit, you can stagger them. So if you're afraid that all of a sudden this minor is going to turn 18 and then wham, there's a ton of money on their plate, it's a recipe for disaster, well, a structured annuity allows for some flexibility to mitigate that risk. Let's go ahead. So let me just hit this real quick. So this is, we're talking about item 18 in the minor's compromise is where you will tell the court that this is what you're envisioning. So we see section 18B2 is where you will identify the blocked account option. And so this is where you have to do some math. You're going to have to figure out the appropriate number to put in the blocked account, or at least what you think is appropriate. And you'll enter it there in your minor's compromise petition, B2. Let's keep going. This is also alluded to by Nadine earlier. There is a judicial counsel form for the blocked account. So this is where you spell out for the court where you intend on depositing the funds. So there's a separate order in addition to the MC 350 and MC 351. And so this is where you present that to the court as well for signature, assuming they agree with your plan. Next one.
Wyatt, there was a question in the chat. Can the court force you to put money in the blocked account, even if you've requested that they're in a structured settlement?
Oh, yeah. The judge is the one who's going to call the shot. If they don't like your plan, they're going to tell you the plan. And that's why, these are multiple rounds sometimes, especially for larger settlements or potentially judgments. You're going to have to listen to the person who's going to be approving this thing. And if they envision something different, or if they have a different plan, then you're going to have to take that into account. And most likely that'll now be your plan A.
It may not be such a problem with your larger verdicts or settlements, your 7 figures. But the judge is going to look very carefully on annuities, at what those upfront charges and what's being taken out of the annuity. In doing calculations, we've had some judges that are very good at crunching the numbers, and you just have to be very careful about being able to address those costs of the annuity, because that's going to be in the top of the mind of the judge as well.
Yeah, no one's skimming off the top, right? They want to make sure that this is a fair deal, and that this is in the best interest of the minor. That's thought number one in all of this.
There's a question. Oh, go ahead, Wyatt.
I was going to say next slide, but if there's another question, let's hit it.
The other question was just how long after the case is settled are you supposed to file the minor's compromise? Is there a limit? I don't know of a limit, but the judge will scrutinize if it's taken a long time. So obviously you want to get it wrapped up as quickly and efficiently as you possibly can.
Yeah, look, I mean, it all flows, especially, there's an incentive for the attorney on their attorney's fees. There's incentive for the client because, gosh, they just, sometimes have gone through protracted litigation. It's now time is of the essence. You got to let them close this chapter on their life, and you cannot let the settlement languish. You'll get an OSC. You'll have to explain yourself if you do not do this promptly. So I think that best practices is to get your plan going right away.
The caveat there, I would say, is the special needs trust, because public benefits, and everyone thinks, oh, well, it's SSI, it's Medi-Cal, it's whatever. It's a lot of that. And Section 8 is a public benefit. And if you take the money, if the money comes into possession or constructive possession of the beneficiary before that special needs trust is established, you may have just completely wiped out their eligibility for those public benefits. And the one that's a particular concern is the Section 8. So yes, you want to wind this up as quickly as possible, but don't take possession of those settlement funds till you've got that trust document approved, and then you can collect the monies and start funding everything.
100%. I'll get to that here in a second, where that is absolutely something you need to be mindful. There is an order of operations, and if you skip a step, it can have catastrophic consequences. So when it comes to the special needs trust, especially, you need to make sure that everything is signed, sealed, delivered, ready to go before the money ever touches the client's hands, because it will impact their asset limits for these public benefits, and like I said, have consequences that you don't want to be dealing with. We already kind of alluded to this, won't spend much time here, but yes, this is the next form. When you have a blocked account, you got to get the acknowledgement. Kind of talked about sometimes that takes pulling teeth in the modern era, but this is the form that you'd be using to accomplish that. Let's go to the next slide. Something to be mindful of with blocked accounts, at least for LA County, is that you're not getting paid until all of this is buttoned up and done. So this is one of the rules, is that you must have the receipt reflecting the deposit being filed with the court in order to get your attorney's fees paid. So that's just something to be mindful of. There's, like I said, an order of operations here.
And you don't want to be the named person on an OSC by the court for you to cough back up attorney fees you've taken to fund the blocked account, because we can't get our MC 356 filed with the court. So yeah, be very careful about that local rule.
All right, so we've kind of talked about structured annuities. Structured goes a long way. You can structure these periodic payments. So college money, money for later support like a house, some combination to help set this child or disabled adult up for their future. Let's go to the next slide. So this is where it's 18B3, assuming that there's no guardianship or conservator. That's where you're going to be saying exactly how much are we investing into a deferred annuity. And that's the whole thing. It's the cost of purchasing it as well as the cost of funding it. And so you're going to outline that for the court in addition into Section 8B2 of the MC31 order. Next slide. Okay, so just here's a sample of it. You can see this is pretty straightforward one. It's just guaranteed monthly payments for life, 40 years beginning at age 18, and it goes. And you can see there's guaranteed benefits, there's projected benefits, and the court is able to take all of this into account to say, is this the best mechanism for this particular minor or disabled adult? And there's always caveats. What the guaranteed benefit is, what per the contract with the annuity company, that is what's going to happen. But there are cases, for example, with diminished life expectancy, where if the person continues to live, they will continue to receive their annuity benefits. If they die after a certain period of time, then that's the end of the annuity benefits. So that's why you get kind of a range there. It's not 100% guaranteed. There's the guarantee and the projected. Let's go to the next one. Then here's one that is much more complicated, much more structured. This is where you can have somebody who is getting certain semi-annual payments, monthly payments, lump sum payments. And so there are a lot of different options. And this this takes individualized considerations. What works best for this minor or this disabled adult based off of their circumstances. And so you see, you invest here. This one was just north of $3 million. And then we get a range of guaranteed benefits and projected benefits. And so again, each case is different. Each client is different. And you just have to take due consideration of their individual circumstances. So we were kind of alluding to this. There is, when you are doing a structure annuity, there is some IRS codes that are implicated. And that's why we do this, QAR. It needs to be part of the settlement agreement such that the obligation to fund the annuity is not going to necessarily the beneficiary, to the minor or the disabled adult. It's actually funded through a third party. And that's what a QAR will accomplish. This is why hiring a structured broker who knows this area, who deals with these every single day of their career, is key, because they will make sure that you're not accidentally getting the money first and then trying to structure it. And now you've completely implicated tax code complications. So be very mindful. There's an order of operations. We can't get into the nitty gritty of every single IRS code here today, but I do want to make you aware of them so that you don't accidentally skip a step. And now you're creating tax liabilities for your client when it was otherwise avoidable. So be very mindful of the qualified assignment.
There was a question about using an annuity for a property damage settlement. My understanding is there has to be some form of physical injury in order to use an annuity. I even deal with that in my sexual abuse cases, because if there isn't a physical, if you don't put it out in a way that it constitutes a physical injury, you may not be able to get an annuity.
Yeah, that would be a tax implication there. My understanding is it does require physical injury, but that for property damage, even severe property damage, I would consult with a subject matter expert on that particular issue, because my understanding is you need the injury aspect of all of this. All right, so statutory minors trust. I know we're getting late on time, so I'm just going to start flying a little bit. But this one is where you need immediate, the case that I did this on, it was the $32 million settlement where the child had a severe TBI and he was about 4 years old. And so he needed a home, he needed medical equipment, and he had enough money that he doesn't need kind of the limitations that Medi-Cal will impose on spending on medical care. He has enough to private pay for his medical care. And so he can buy insurance and he can handle it that way because there was so much money. So that doesn't necessarily mean it's just limited to mega settlements for a minor, but there may be some of more moderate area where there are the need for the house, need for a car that can address the transportation needs of the child. But this is typically where you want to be thinking that, hey, we need to take care of this kid now, and we can't deal with the restrictions that a special needs trust will impose. And so you at least want to explore a statutory minors trust. And we kind of go to mix and match. The mix there is on the right. We can have an annuity structure that will pay out for at least till the age of 18 into the trust. So you're going to get periodic payments. When they hit age 12, boom, lump sum from the structure. Age 14, another investment of cash. Age 16, more cash comes into the trust. So you pair this statutory minors trust with a structured annuity, and the two can come together to make sure that there's a constant cash flow into the trust, so that you don't just get one lump sum in the beginning. It sits in trust, it doesn't earn interest, and it just is kind of trickles out on an as needed basis. You can have cash in the trust, pair it with the structure, be able to have all of the needs met across time. Let's go to the next slide. So B7 of your minors compromise, that's where you're going to state how much we're going to be putting into the trust. If you're doing a structured annuity with it, it would be B3 with B7. Both boxes would be checked. Both boxes would have money, the amount specified. Let's go to the next slide. So here's a quick sample. Statutory minors trust. This is just the caption page. Obviously, there's a whole bunch of terms. You will need to hire a trust lawyer to prepare your trust instrument, but this is just kind of a sample of what it looks like. And you'll see attachment 18B7. You literally attach this to your MC 350. So it is included along with all the other documents that you're preparing and submitting to the court. Next slide. B2, you'll literally be attaching this to the order as well. MC 351, you'll have an attachment B2, and if there's multiple funding structures, you'll be B2A. So you'll have multiple attachments, including the entire trust instrument to the minors compromise order. Next one. We discussed, or maybe we alluded to it earlier, is that once you have a minors compromise that is going to require ongoing probate supervision, for LA County, there's a local form that you need to fill out and you need to attach to a certified copy of the order so that now we can get the process rolling with the probate court. Let's go to the next slide.
If I could just mention that form is in the, there it is, PRO 044. Sorry.
No, perfect. Yeah, no,
Right.
exactly. I was only because of you, Judge Luna,
Okay.
to get directed to this. So yes, so here it is. This is something that once you have that signed order from the court, the civil court, assuming that it was ongoing civil litigation, this is what you're going to file to kick off the probate proceedings.
Form numbers in the chat.
All right, special needs trust. So we can fly through this. Let's go to the next slide. So this, like we've alluded to throughout today, this is to protect the assets of the minor, make sure that they continue to maintain their benefits. But I will say, just even preparing for today's presentation, there have been so many changes to this area. It is a very fluid area of the law in terms of what the asset tests, what's eligible for assets, what counts against assets. So we need to be very mindful that these rules are fluid. And so the lesson is to be mindful of the fact that this landscape can shift fast and you need to consult with a subject matter expert. Some of these settlement brokers, they deal with these issues constantly, so they can help you understand when these benefits can be jeopardized if you choose the wrong structure for your client. So yeah, so now we're on for when there's no conservator guardianship. B4 will be where you specify how much you're putting into the special needs trust. Let's go to the next slide. Here's a sample of the face page for a special needs trust petition. You'll see that this one was in Riverside, so it actually was filed directly into the probate court for this particular case. Again, there's a lot of trust terms. One thing to be mindful of, I think we maybe hit this a little earlier, is there's some notice requirements if you're creating a special needs trust. 15 days before the hearing on the petition to establish special needs trust, you're going to need to give the Department of Healthcare Services notice, state hospital, developmental services. They're all entitled to notice before you're going to be able to get a trust of this nature established. So something to be very mindful of.
Can I make one comment real quick, Wyatt? If you go back to that petition, you have there, in this particular case, you're asking for authority to purchase real property. I think what would be helpful coming from the plaintiff side is making sure whoever's going to be administering that special needs trust has your life care plan or your day in the life video or both, because if you have to show to a probate judge why you need release of money for a certain expenditure or why a certain expenditure was made during an accounting period, it's very helpful for the court to have an idea as to what is going on with this particular beneficiary, especially if there's family living in the house or that will make use of whatever the improvement or vehicle or whatever it is that you're asking the special needs trust to pay for. So just kind of a practice tip to transfer or have those materials available to the trustee of the special needs trust.
Yeah, and look, I mean, actually, let me piggyback on that a little bit too, is that part of this, we're kind of flying through the surface level, but you're going to have to help your guardian ad litem get paired up with an appropriate fiduciary, the person who's going to be serving as trustee of this trust. It doesn't always have to be a licensed fiduciary professionals, but they need to be able to get bonded. If you can't get bonded, you're not going to be able to serve as trustee. And so that's where the private fiduciaries will be able to have those qualifications at the ready, as opposed to it becoming a process to get a bond. And then they're going to need to be armed with the information to try and make sure that you can facilitate the needs that you, as the subject matter expert, because you know your client just as well as anybody, their specific needs for this settlement fund. And so if you don't arm the trustees with the requisite information, they're not going to be able to accomplish what you're seeking to provide to your client based off of all the knowledge that you've gained throughout your case. So yeah, it's information is power. And if you have these expert reports and you're just keeping them to yourself, you are not really putting your client in the best position moving forward post-settlement. Let's keep going. All right, so yeah, attach it to the order B2. Everything kind of, a lot of this flows into the order B2. Let's keep going. I won't hit this one too long. Let's go to the next slide. This is a little bit of a unique circumstance. It's when you can't get a private fiduciary who wants to manage your client's funds. This is kind of, the time I've done this was because my client, she was transient. She was unavailable for months at a time. She was unmanageable. And so there are nonprofit associations that create pooled special needs trusts so that we can keep the person's benefits eligible should they take advantage of them. But it's managed by this nonprofit that sometimes they have social workers that are on staff to be able to deal with this kind of unique clientele. They are operated with some state approval in terms of being able to create a trust mechanism of this nature. And you don't actually even create a trust. The master trust is already established. It's been established usually for months, if not years, if not decades. You just create a joinder agreement to join into the pooled special needs trust, and that's presented to your civil judge, presented to the probate court, depending on your jurisdiction. And so it's a unique case when you have kind of that client that is not necessarily as cooperative as you would like. And we've seen that in some of the adult disability cases. So yeah, here, and you see it, you can just see in the title there, it's a mouthful. And there is a lot of implications there. This is something you certainly would not do without consulting with a subject matter expert. I think on this case, I had multiple subject matter experts because it was very complicated and kind of emotionally taxing as well. So yeah, you want to get a little bit of a small army together if you're going to be creating a trust of this nature or joining a trust of this nature. So okay, we've gone through it. Kind of the final thoughts are that make sure that you understand that your job does not end at day mediation or the day the verdict is reached. You have to take a lot of planning to make sure you're setting your client up for success in the future. And if you don't do a good job, it might not end well.
I want to thank everyone. I don't know if Ned is still on, but thank you everyone for jumping on. I even learned some stuff today from both Judge Luna and Wyatt on things that I want to incorporate. We are all willing to help, I think. So we've put our emails here. If you guys have any questions, need some samples. I know we didn't get to every single question in the chat. I tried my best here. But thank you so much for joining us today. Any parting words, Judge Luna, Wyatt?
No, thank you for the opportunity to present.
Yeah.
Alrighty, this concludes today's presentation. Thank you so much for taking the time to educate our members today, and thank you so much to our audience. Have a great day, everybody.